truth, logic, common sense, that gut feeling, and yes, even a little psychoanalysis, as we are once again together, you and I, to discuss Chad and Lori Daybell. Well, folks, we sure do have a lot of pre-trial activity going on. We've been over several different legal documents here in the last couple of weeks. I imagine it's going to continue to ramp up. And then, of course, we've got on the portal, there is some lines in there where it's talking about sealing this and sealing that. The judge is making sure that anything and all is on the up and up, I'm assuming. It's very frustrating for all of us. But as I was going down that portal, I thought, well, what do we need to go over in terms of filling in those little mosaics in the overall justice through understanding of this case? And I want to bring to y'all's attention something that on face value looks as though it's just a formality, but you can find clues to not only the state of mind of the state and where they're going with Lori and Chad, but also the defendants themselves. I posted on the community wall the term mens rea. It's a legal term. And basically what it is mens rea refers to what, y'all? The one thing that I pounded at the beginning of this channel opening that has to be proven. Criminal intent. Mens rea refers to criminal intent. And the literal Latin translation is guilty mind. And, you know, I would assume that some of y'all would be like, well, KJ, we've done talked about a lot of this. We know Chad and Lori. They're evil and diabolical. They absolutely had the criminal intent. And obviously, y'all, there have been times that we're like, did Lori think she was in her intentions when the children were murdered, when Charles was murdered, when Tammy was murdered? Was there just any way at all that she could prove that her mind was not criminally thinking? She was more, her intent was she thought she was ridding the world of zombies. I mean, get for real, y'all. Anybody can make up shit when they get busted for murdering somebody. And they can say, in my mind at the time, I thought I was ridding the world of zombies. I thought my children would be free and Nick Schneider wouldn't bother Charles anymore. And Tammy, you know, she had Viola in her and Julie Rowe was knocking on the door and blah, 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 blah. But the bottom line is this, y'all. Chad and Lori's criminal intent. What they did in all of this. You could say, well, they are criminals, KJ. They murdered people, but it has to be established in a court of law that they had the intention to do criminal things, that they were reckless, and any normal person in the world would have known if you do this or that, this is what's going to happen, and it's just reckless in nature. There's 3 types of mens rea, and only one has to be proven. Please visit the community wall, because folks, listen up. When it comes to justice through understanding, it means a lot of different things to a lot of people. But understanding means what, y'all? It means learning about something. You cannot understand something that you don't learn about. And many of y'all that's been around for a while know that, oh, KJ's not all that smart. I just got to research and analyze things and share it with you. And many times, many of y'all have educated me. So let's get into this document. The state has filed a pretrial motion in limine. And some of y'all know what that is, and we'll go into that. But they filed this motion in limine on Chad and Lori. And just keep this in mind. Neither defendants are opting to go for a mental health defense. We know Chad all this time. He hasn't seen any psychologist, psychiatrist. He hasn't been committed for competency issues, and Lori is on the opposite end of that. She's been in the Idaho Department Health and Welfare's care, and even this other break that they had after she was ruled competent. They did it again. Because Lori had competency issues, the state files the same motion with Chad's case number and hers, but the motion in limine, but at the same time in Lori's case number, they give a memorandum in support of the motion, which could apply to both. They don't have to put the memorandum in both case files, but they do have a motion in limine for Chad Daybell and Lori Daybell. And I guess really if you want to say, well, KJ, well, what are we doing here? What are we going to learn? I guess what my lens and my focus is the question. Really, it really comes down to if they both believed the same shit, then how could one, but not the other, have mental illness? In other words, if there was some way that Lori could bring it out in the trial, now we're not talking about if she gets convicted and the penalty phase. We're just talking about the trial. And somehow evidence would come in to show Lori had mental illness, but she believed the same things as Chad. A jury would be like, well, wait a minute. Chad and Lori believe the same things, and yet her defense attorney is trying to say, well, she only believed this stuff because she was mentally ill. She was delusional. Again, let me just state off the bat that both defendants have made it very clear in their filings. Neither will have the mental health defense. So we're going to go over this motion in limine, but first let me tell you what a motion in limine is, because I had to learn as well. A motion seeking a pretrial ruling on evidence that could be admitted in the trial is known as a motion in limine. Idaho courts recognize the importance of a motion in limine. A motion in limine enables a judge to make a ruling on evidence pre-trial without first exposing it to the jury. It avoids juror bias, sometimes generated by objections to evidence during trial, and the court's ruling on the motion enables counsel of both sides to make strategic decisions before trial on the content and order of evidence to be presented. So again, there's a lot of pretrial activity going on in a motion in limine from the state. They're saying we have something that needs to be ironed out before we go to trial. And why would they say this? They go on to explain it. The number of charges, says the state of Idaho, Rob Wood, Lindsay Blake, and Rachel Smith. The number of charges, the existence of two jointly charged defendants, the acts of the defendants spanning into different counties and our states, the extent of the conspiracy alleged, the significant amount of witnesses, and the number of law enforcement agencies involved make the trial of these actions complex. And we all know this. We know jurisdictionally, we know the different law enforcement, whether it was Gilbert, whether it was Rexburg, whether it was the FBI. The state, the court, and even the defendants will be best served by resolution before trial of any issues that can be resolved to reduce potential confusion during the substantial trial preparation. And what the state is saying is we got all this motion in limine that helps the judge, that we say, hey, judge, in case this is brought forward by the defense, if somehow they want to bring this certain aspect out as evidence in a trial, we need to iron this out now, because we don't want to go through all this crap during trial that might bias a juror if we have to stand up and say, I object to this. And the state has a very good reason for this motion in limine. The state requests this court enter an order in advance prohibiting the defendants, Chad and Lori, from presenting evidence from a mental health expert at any time, y'all. Which falls under the same theory of Idaho Code 18-207. Now, before we move forward in this, let me just say this. I needed to back up. There was something I missed When the state is talking about the complexity of this case and they talk about spanning into different counties and our states, this gives old KJ a little clue. What kind of clue am I speaking of? When we're talking about counties and states, are we talking about Arizona? Is this another motion in limine that eventually will make it before the trial where the state says we don't need these prior acts in Arizona from Lori and Alex to come in? You see, they're pointing to it. They're saying there's different jurisdictions. And if they're saying it in their motion in limine, eventually it's going to have to be resolved. The state requests that this court enters an order in advance prohibiting the defendants from presenting evidence from a mental health expert at any time, which falls under the same theory of Idaho Code 18207. And if you'll listen, you'll learn and you'll pick up on these clues. There are nuggets in there, folks. Yet, which would be complete contradiction and violation of discovery requirements of Idaho Code 18-207. There are discovery requirements that have to be met, y'all. If you recall, we talked about the scheduling conferences and all of this thing. If you're going to have a mental health defense, you've got to let the state know in advance. If you're going to have experts, you've got to let them know. 90 days, I believe, but we'll go through here and see. The state asked the court to issue a ruling that the introduction of evidence of the defendant's, what? Mental illness? No. The defendant's beliefs, y'all. Here we go. Is not a justification for the defendant to later argue the door has been opened and then attempt to bootstrap the introduction of mental condition evidence as a defense to negate guilt or for any other defense purposes in violation of the Idaho Code and discovery requirements. And what the state is saying is, well, first of all, Lori has made it clear, and Chad, that they're not going for the mental health defense. So when they get into this when the state has to get into all this about they endorsed and espoused religious beliefs for the purpose of murder, the defense the state is saying is, you can't say that this is a way to get in through a back door to talk about mental illness from their frame of mind, beliefs. They're saying is different than actually having a mental illness. So then the state says the defendant should be prohibited from the use of an expert witness regarding mental health or mental health defense. And let's just be clear. The state is talking about it anytime, but specifically we're looking at pre-trial rulings from a judge to decide this issue. So this would encompass the trial itself. And so the state is saying, hey, if she's not going to have a mental health defense, number one, her beliefs ain't got shit to do with mental illness. Number two, this why would they even try to introduce this as a way to negate or to make it look less of a guilt on Lori or Chad by saying that their beliefs were somehow related to some sort of mental health issue. Idaho has recently reiterated that, stated more concisely, the United States Constitution guarantees criminal defendants a meaningful opportunity to put on a complete defense. And one might say, well, KJ, a complete defense would mean the defense would have to bring in all this stuff about Lori, in the trial, that, she was mentally ill, and you couple that with her belief system, and bam, this makes her less guilty, which is a crock of shit, really. But it says, nevertheless, a criminal defendant must still comply with the rules of procedure and evidence to ensure a fair and reliable trial. So, although the United States Constitution says they need to put on, the defendants, they should be able to put on a complete defense, they still have procedures they have to go through. And in this particular case, they spell this out. The defendant has failed to comply with the requirements of Idaho Code 18-207, and I've said Idaho Code 18-207 3 or 4 times already. Well, here is the code on it. Mental conditions shall not be a defense to any charge of criminal conduct. And Idaho Code 18-207, Section 3 says, nothing herein is intended to prevent the admission of expert evidence on the issue of any state of mind, which is an element of the offense, subject to what? The rules of evidence. Because in order for the state to get a conviction, they've got to have that mens rea. What was going on in Lori's mind? What was going on in Chad's mind at the time that all these murders took place? So the code does specify that, yeah, you could talk about, if you've got evidence defense of what their state of mind is, that's fine. But you can't say their state of mind was mentally ill and that's our defense. Unless, of course, they file the proper paperwork. And we know Lori and Chad both. As we go down through here, you'll see, and it's confirmed that even Chad's attorney, John Pryor, he also says no mental health defense. Should the defendant attempt to admit such evidence, the defendant will not have complied with the relevant Idaho statute. Idaho 18-207 4A requires 90 days. And the 90 days was just about up. And that's when we saw on the portal where Lori is not seeking a mental health defense. 90 days notice prior to the trial of the intent to put on a mental impairment defense. The jury trial will now begin in less than 90 days. Moreover, the defendant explicitly just gave the opposite notice, affirmatively stating that, in fact, Lori does not intend to have a mental health defense. Idaho Code 18-207 4B further requires the report of any proposed expert the defense would intend to use to be disclosed to the state in adequate time to prepare for rebuttal of the defense expert. The defendant has not provided any such synopsis, reports, or documentations. That's required. Idaho Code 18-207 4C requires the state then be provided access to the defendant for a mental health examination by the state's chosen expert. And that never happened. Remember initially when Lori was with Mark Means, they got someone who was neutral. The court did. It wasn't the defense's expert. It wasn't the state's expert that initially put Lori in the damn spa for competency issues. But according to the statutes and codes, if the defense is going to say, we've got this expert or we got this psychologist, they haven't filed that this is what they're going to do in enough time for the state to be able to rebut it and say, okay, and also they themselves, by law, should be able to have their own expert evaluate Lori or Chad. The defendant has not permitted such an evaluation. In fact, as to evidence of mental issues at the time of the charged offenses, Idaho Code 18-207 4C establishes that if a defendant refuses to meet with an expert, then the defense may be unavailable. That defense of mental health defense is unavailable if she doesn't meet with a state's expert to evaluate her mental illness or whether she has one. Or at least at a minimum, the jury may be instructed to consider the defendant's refusal to undergo the evaluation and or meet with an expert, which the state says, well, Judge, if you're going to let this happen, if you're going to let this expert come, then you need to be able to at least put in there that the jury gets to know that Lori wouldn't allow the state, their expert, to look her over and decide what they thought. And that would be damning for a juror. Juror would be like, well, why wouldn't she? If her expert said that she had mental illness, then why would she have a problem meeting with a state's expert, right? On January 6th of 2023, y'all, which is just a few weeks back, Through counsel, the defendant filed a notice of intent not to raise a mental health defense to her charges, thereby expressly waiving her right to do so. The state has no access to any proposed expert report or testimony which may be presented regarding her mental health or mental condition at trial. Further, the state has not been provided an opportunity to have an expert for the state examine the defendant to assist in forming an expert opinion. Given the defense's discovery, and this is Archie's discovery, things he's got, the discovery announcement, there is no way to know whether or not the defendant would have subjected herself to examination as required for the defense to be presented, further limiting the state's ability to respond as contemplated by Idaho Code 18-207. And what he's talking about, the discovery announcement, that's what Archie filed. It was discovery saying we are not going to seek a mental health defense. So the state, well, okay, but there's no way of knowing this. When mental health has not properly been raised pursuant to Idaho Code 18-207, the appropriate jury instructions is Idaho Criminal Jury Instruction 1505, which provides, our law provides that mental illness is not a defense to any charge of criminal conduct. This means that mental illness, if the evidence shows such a condition existed at the time the defendant allegedly committed the crimes charged, it's not a defense. So the defense, again, not only are they not going through the right procedures and doing the right things, the state has no idea what the defense is doing. This is exactly why they're saying, Judge Boyce, we need this ironed out now so that we ain't blindsided about all this. Considering the waiver of the mental condition defense and the defendant's admitted lack of compliance with Idaho Code 18-207, this court should now issue an order precluding the use of an expert by the defense regarding the defendant's mental condition, and an order barring the defense from presenting evidence or argument of a mental condition as a defense in any situation. So what does this tell, OKJ? This is another clue. If the state gets their way on this and the judge goes ahead and he says, well, you're right, they didn't give you enough notice for an expert and all this and that, defense, you can't do this, you cannot bring this in, you can't talk about it in your defense, then that tells you in the trial that we're not going to hear anything about Lori's mental illness. And obviously she's got one, and many of us have hypothesized what that could be. But then again, it goes further in talking about something else. Considering this waiver, the defendant is precluded from offering mental condition evidence based on Idaho Code law. In 2020, the Idaho Supreme Court upheld a felony conviction despite exclusion of belated evidence of mental incompetency because the evidence was not related to or relevant to the evidence on the prerequisite of mens rea. What was going on during the time that Lori and Chad were murdering these people, murdering the children, murdering Tammy? You know, their frame of mind. What would the defense absolutely outside of bringing up mental illness? How could they prove that at the time these murders took place that Chad and Lori had no intent at all, criminal intent, to murder anyone? And he goes into a case, and I won't go through all that, but I will say this. In conclusion of that case, it talks about in the proceedings below, which I'm not going to bore you with, the defense counsel explained that Dr. Trauber would testify as to Oxford's clinical diagnosis as contained in his report, which only addressed Oxford's mental state at the time of the interview. Thus, the district court did not err by concluding that Dr. Trauber's testimony would not have assisted the trier of fact in determining Oxford's state of mind at the time of the criminal conduct. So what that means is hey, The state saying, we got case law here that says that, you can bring in your expert all you want, and say whatever they want to say, but they wasn't there when these charges dropped. They have no evidence. I mean, think about it like this. Lori steps into an expert that Archie gets, right? One of these psychologists. She can make up all kind of shit now saying this was her frame of mind at the time. But unless they have evidence to back that up, then it's what the Supreme Court of Idaho says is, hey, you can't bring someone in here to say, well, I interviewed Lori, and this, I believe, was her state of mind at the time. Because that just ain't going to float. It's not. They can say anything, do anything. Similar to the defense in Oxford, the defendant, Vallow Daybell, previously had been found incompetent to stand trial for a time during these proceedings, but is now competent. Also, like Oxford, the defendant apparently has never sought, or at least not provided, an evaluation as to her ability to form mens rea. So there is no report out there that the state knows about. That there's nothing in the defense's discovery that says, we did when Lori got arrested, we got this done. This was a evaluation that was curtailed specifically for her frame of mind. And of course, her ability to form mens rea at the time of the charged conduct. Defense evidence on the defendant's mental condition at the time of the charged conduct is an absolute prerequisite. You gotta have that for any application of Idaho Code 18-207 to present negation. In other words, to get back, negate any of the specific intent as a defense. The defendant has failed to raise such a defense in light of 2 points made in Oxford. First, she has produced no evidence. She hasn't. Archie hasn't. Chad hasn't, really. Of course, he never had this whole ordeal, but it's in his case file that this motion in limine applies to him as well. But first, she has produced no evidence of her mens rea, and second, there's no expert witness form information providing such mens rea evidence addressing her condition at the time of the offense. In present situation, it was almost a year before any mental health evaluation of any sort was ever performed on Lori. Much more than the mere 7 weeks, the 7-week delay that was objected to in Oxford. In other words, hey, this Supreme Court decision that explains all this, that was only 7 weeks, but Lori's is more than that. As far as the state is aware, no mens rea evaluation has ever been done in this case, and if one has, it has never been provided to the state, and the defense has to provide that within 90 days. The court should now rule that the state's admission of testimony or evidence about the defendant's beliefs, doesn't say mental illness, it says the defendant's beliefs, does not open the door at trial to the defense's use of a mental condition as a defense. And why should it? They come out and said, we're not using this as a defense. But they can't sit there and come through another way on their defense by saying, well, because she believed this way, we're going to have an expert come in here and they're going to explain because she believed this, or this, zombies, whatever, that this was delusional, this is mental illness. Well, they can't do that because they're not asserting it. And on top of it all, the state hasn't had a chance to even meet with this expert who's supposed to, the defense is supposed to let them know within 90 days. Relative to resolution of issues in advance of trial via motions in limine, the Idaho Supreme Court noted this: it avoids juror bias sometimes generated by objections to evidence during trial. Again, it is very possible and even likely that the state will introduce evidence regarding the defendant's beliefs or views. So there's another clue, y'all. Another nugget. The state is telling in this motion in limine, saying that we are going to introduce possibly evidence regarding the defendant's beliefs and our views. this court should order the admission of such evidence by the state that it doesn't open the door for Archie or John Pryor to come out there and say, because y'all have got evidence, state, y'all have showed clear empirical evidence of their belief system, that we now want to come in and rebut that and defend our clients by saying, well, they had to have been delusional or mentally ill. You can't do it. This court should order the admission of such evidence by the state does not open the door for the defense to offer undisclosed, unnoticed evidence, or even argue to the jury that the defendant's beliefs and or views should be viewed as delusional, a delusional condition diminishing their guilt. The defense saying, because the state is giving y'all evidence of their belief system and how they were going to murder them because they said they were zombies or whatever, we're trying to tell you that that was delusional. And the reason we want to tell the jury that it was delusional or that they had a mental illness is because we don't want them to look guilty as shit, basically. The defendant chose to give up her right to present a mental health defense or evidence at any part of the guilt phase of her trial, January 6th of 2023, via her legal counsel, Archie. The defendant's decision was made knowing that the state would likely present evidence regarding her beliefs. Allowing the defendant to argue the door is opened by the state with its use of such evidence during trial would allow for an end run around Idaho Code 18-207, improperly allowing the defendant to argue such as evidence of delusional thinking. Think about that, y'all. Just think about that. If Lori could get out there and her defense attorney Archie got out there and the state, they do have to. There's no way around it. They said it in the indictment, endorse the spouse religious beliefs for the purpose of murder. Why even put that in there? Why don't you just put they wanted to be together or they just were criminals and they just murdered? Why did they add endorsed and spouse religious beliefs? Well, I'll tell you what, the state has pinned themselves into that. They've got to talk about Lori's beliefs. They've got to talk about Chad's beliefs. And hopefully the state will drive it home that these two assholes both believed exactly the same thing. And so if Archie was able to say Lori was mentally ill, she was delusional, but John Pryor doesn't do the same, then the jury's going to be like, well, wait just a damn second. This would grossly and unfairly undermine the provisions of the statute, which clearly serve to give the state ample opportunity to prepare to meet such an argument long before trial. This cuts at the very core of the notion of providing the defense and the state a fair trial. The state respectfully requests that the court grant the motion in limine and prohibit Lori and Chad from using evidence provided through a mental health expert, using evidence that is not disclosed or properly noticed, and prohibit improper argument on mental health and or a mental health defense that does not follow Idaho law. The state requests this matter be set for oral argument at the same time as the state's motion for inclusion of evidence. And there you go. So in a nutshell, what is KJ telling you? I'm telling you now that when Chad and Lori did not, within the statute range, are supposed to let you know whether they were mentally ill or not. Chad's never done anything like that, and Lori has, but they both are not having a mental health defense. The state is saying pre-trial, a motion in limine. Let's get this out of the way so the defense don't come in here and say some shit about Lori or Chad being delusional, and that we've got to object. And by the way, Judge, how in the hell can they bring in an expert witness on Lori or Chad's mental illness to try to make it look like they're less guilty, that they didn't have the mens rea, the criminal intent, because the experts saying, well, they just meant well. They thought they were releasing the zombies out of the children so the children could go on to a different life and Tammy could go wait for Chad and on another planet or whatever the hell. And then the jury hear that, the judge will most likely, I cannot see, according to Idaho statute and codes, allow anything that Archie or John Pryor can say about the frame of mind, the mens rea of Chad and Lori being delusional or mentally ill when it relates to their messed up and screwed up beliefs. So I just wanted to share that with y'all. Please leave it in the comments what you think about the fact that the state is very clear. No time during any of this, no time during any of Chad and Lori's pretrial stuff have they ever given any kind of indication of what was going on in their mind. No evidence, no discovery from either one of the defense attorneys of what was going on in their mind when they murdered those children in Tammy Daybell. It's very interesting to say the least, and it tells me a lot. It tells me that the state is saying, let's get this out of the way now. Now that we know y'all have given us notice, no mental health defense, so don't even try to get through a backdoor way to try to make your clients look less guilty. Their beliefs were their beliefs, and the state's going to bring it out in evidence, whether it's text messages, whether it's the stupid ass light and dark document, whatever it is, the state is going to bring it out, and they're not going to be able, the defenses are not going to be able to say that their belief system was all about mental illness. You and I both know that Chad and Lori are evil, diabolical serial killers, psychopaths, narcissistic. Those things are evident, and I think most jurors would see that. But we need to understand that as trial approaches, if any of us are going to think that maybe John Pryor or Archie there is going to bring out in their defense that, at the time Lori said that, she was at home in her apartment and the kids were murdered over at Alex's. And by the way, the state has filed a motion to compel saying, well, you can file this damn alibi all you want to, Lori, but there ain't no dates, no times. Give me a break. The bottom line is the jurors are going to want to be able to prove one thing: criminal intent. And perhaps maybe through a mental health defense that is way past now, procedurally able to be done now. The bottom line is that the defense has hamstringed themselves. I would have thought, I can't understand it. Other than to say, Lori, it says, Archie said in that hearing, he said that she's taken an active role. Maybe she doesn't want people to see her do a mental health defense. Maybe she wants to be right, like Chad, right? The bottom line is that they've got a lot of explaining to do, don't you think? So, when I get back with you, I've got another pre-record coming. This will be related to Chad Daybell's alibi that we know nothing about, but I've got it on the community wall. John Pryor has sent that private service to the state. He doesn't want it for public consumption. Lori's was. Obviously, we know now that even though she does say she didn't know before, after, and wasn't the principal, and that she was in her apartment and the kids were murdered in Alex's, it doesn't give much details either. One has to wonder what Chad Daybell's alibi is. That one might be a little bit longer of a pre-record than 39 plus minutes. So leave your comments. Let me know what you think. And keep on looking.